Bismillahirrahmanirrahim. Assalamu alaikum, dear students. Hope all of you will be doing well at your respective places. In our today's lecture, we will be discussing contract of agency, and in second part we will discuss how agency is created between the principal and the agent, and then we will go towards duties. What are the different duties of agent which he must perform on behalf of the principal, and then we will go towards we will discuss rights of agents, as rights and duties are two sides of the same coin, so both of them needs to be discussed in law and as well as in business law. Then we will go towards duties of principal, and then we will come towards that how the agency can be terminated by either law or by mutual consent of both the agent and the principal. So as you see, students, in the slide, agency is created by these following ways: express agency, implied agency, agency by holding out, agency by estoppel. Now we come, boys, to the first form, that is express agency. What is express agency? Express agency arises when authority is given by the principal to his agent by words spoken or written. It is called an express agency. Generally, the principal creates contract of agency by writing a power of attorney on stamped paper in favor of whom? In favor of the agent. Example will be: B appoints C as his agent to sell his house. It is an express agency. B writes a power of attorney in favor of C and authorizes him to sell his plot. It is a written express agency. So it can be by words, and it can be both by words and in writing, but in writing is much more better than words, because it clears the intentions of principal in agent, and if there arises any confusion regarding the rights and duties or the basic purpose of agency, it will be cleared by the written words of both in the presence of witnesses and other legal requirement. Now, what is implied? Express is when there is no ambiguity in it. Implied is again a sort of agency that is created by the implied behavior of the principal or agent, and when it arises, an implied agency arises from the conduct, situation or relationship of parties, i.e. principal and agent. It does not arise as a result of express agreement or contract. While in the first place we see that there is a clear words from principal who authorizes someone to act as his agent. Over here there are no words, but the behavior of either the agent or the principal that shows to other parties that a specific person, let's say Mr. X is principal and Mr. Y is his agent, and people believe that there is a relationship of agency between Y and X, and Y uh, execute the work on behalf of Y, who is his principal. Now it can be cleared by an example. X and Y are brothers, and X lives in Lahore and Y in Multan. Y, with the knowledge of X, gives his land on lease. Y collects rent and remits to X. Y is implied agent of X. Let's say there are two brothers, A and B. One is living in Islamabad, the other is living in, let's say, Peshawar. A living in Islamabad, B in Peshawar. Now A has some land in Peshawar, and he leased that land on the assent of A. Yeah, A gives the land on lease to someone, and B, his brother, collects the rent on behalf of A, or let's say behalf of A, his brother, his elder brother. Now B is an agent in this legal relation. B acts on behalf of his elder brother to collect the rent from C, who has some land on lease from A. It is implied agency. Both of them are important in business terms as well as in normal life, that we should understand. Agency by holding out, it is very important, boys, and it occurs, guys, in practical life, that some technical relation arises between the agent and the principal. Agency by holding out is similar to agency by estoppel. It arises when person by his past conduct includes a third person to believe that particular person doing some act on his behalf is doing with authority. For example, B, through his servant C, buys goods on credit from D on regular basis. On one occasion, B gives cash to C to buy goods. C misappropriates the cash and buys goods on credit from D. D is liable to D for payment. Now, if you have a servant, let's say, and you purchase goods from some grocery shop and you pay him at the month end. On, let's say, someday you give some cash to your servant and ask that bring these things from a grocery house on cash, and he, instead of purchasing the goods on cash, misappropriates the cash, and later on when you go to the shop and the shop keeper, the grocery shopkeeper, give you bill for goods, and you said that I have given him cash, and he says that he does not give me cash but bring the goods on credit. Now you will pay the grocery shop because your servant was your agent, and he was authorized by you to bring goods from the grocery shop to home on need basis. So sometimes such situation arises, so you should be very clear in your mind that not to do such acts on which later on you are in some sort of financial obligations, are in a legal problem. Agency by estoppel. It is again a French word, estoppel, and what it means to the term estoppel means to prevent a person from denying the truth of a statement. Truth of a statement. Agency by estoppel arises when a person by his words or conduct induces a third person to believe that a particular person is his agent. The principle is prevented from denying the existence of the authority. For example, Mr. A and B are standing in a gathering, and C is also standing talking to him, and B says that I'm agent of A and will do these acts on behalf of A for you to transact any business on behalf of A with Mr. C. Now A remains, A says that he is my agent in front of C. Now there is no written agreement, and B does the transaction, the business on behalf of A with C. Now A later on denies that B was my agent and he was doing this transaction with you, and I am not liable for the acts of B. C can sue him that you told me in front of this gentleman that he is my agent, and people in the market are also doing business with B, assuming that you are master, you allowed him to transact on your behalf the business deals. Now A, who is the principal, cannot deny the fact, and if there arises any legal complications or damages which C claims on B, B as A as his master must clear those obligations of C against B, because you in the meeting as does not deny the fact that B is not my agent, rather you give a positive assent in meeting or anywhere that B is my agent. So such sometimes technicality arises, especially in the last two, agency by holding out. Agency by ratification, this is again the fifth part. Let's say there are three parties, A, B, and C. B does some business with C. Let's say B is your tenant and he sells your wheat to C, and C assumes that B is your agent. You are party A and you endorse to see that yes, B did this job on behalf of me. Now you ratify a relation. Ratification gives a legal relation between the parties as A and B, A principal, B agent, and C an external party who transacts with B on as B is doing business on your behalf. Agency by operation of law. Sometimes a situation arises where you does not appoint someone as your legal agent, but he acts on your behalf due to some emergency situation. That is called agency by operation of law. When it arises, there must be emergency to act on behalf of the principal. There must be real necessity to act on behalf of the principal. It must be possible for agent to get the principal's. It must not be possible for agent to get the principal's instruction, because let's say some fire broke and you cannot contact the principal. So whatever reasonable things are needed to stop the fire and save the business assets from destruction is necessary on the part of anybody who act in good faith, or rather you have somebody has sent goods to Karachi and through a driver. Now the driver sees it's occur that the goods are of perishable nature. fruits, etc., and they may perish uh, when reached to Karachi, and he sold them in Sakkar or in let's say Larkana. So he acted in good faith. So here arises the agency in the original owner of the goods does not deny that the truck driver who was not agent sells the goods in the market for the in a good faith to save them from perishing and in saving the principal or master from loss. So these are different sort of agencies which normally were created by the law. We can see that the first one, that is express agency or written, that is very much clear, and the other agencies are again created due to the dynamic nature of business and social relations in societies. Now, what are the duties of agent? The duty of agent is to perform his job as directed by the principal. If let's say there are no directions, then there will be some established principles, conventions for doing a certain job. So the agent must follow those conventions and customs. For example, we ask his agency to ensure the goods. She neglects to do so. She is liable to compensate B if goods get damaged. Skill and care. There should be reasonable skill and care applied by the agent on behalf of the principal. For example, an agent must act with reasonable skill and care. Reasonable skill and care means skill that is possessed by the persons engaged in similar business, on similar positions, people working, how they apply their skills and care to the interest of the principal. You should also apply the same as agent of the principal. Example is, B, an agent sells goods on credit to C without inquiring about his solvency. B is insolvent at the time of sale. B must compensate his principal for loss. Should be clear to you, students, from this example. Submission of accounts. Agent must give objective accounts of whatever business transactions he carried on behalf of the principal, like the management of any company do on behalf of the shareholders, and company audited their accounts from CA firms, and directors also sign them in the form of balance sheet, profit and loss statement, cash flow statement, income statement. Contact one principal. It is duty of the agent to contact principals and get guidance and directions from him for execution of any decision regarding the business. Protection of interest duty. It is the most important duty of any agent to take protect the interest of the principal. They may be business interest or other interests. Disclosure of facts. The agent must disclose all the facts to the principal. He should not hide anything which he performed on a position which has which give him some authority. For example, you are manager purchase and you do transaction on behalf of the principal. You should disclose all the facts to him regarding whatever you have transacted with other parties. B directs his agency to buy a certain house. C buys the house for himself. B cancels the contract. For example, you ask someone to purchase a house for you, his agent for you, and he, instead of purchasing the house to you, purchase it for himself. You, principal, can reject and sue your agent for damages. Disclosure of facts. All facts should be disclosed. Delegation of authority. Agent cannot further delegate his authority, as the principal delegate his authority to him, that he, the agent, will act on behalf of the principal. Now, if the agent further delegates authority to someone else, it is illegal. It's per law. Now, what are the rights of agents? Now, first we discussed till this time boys and girls, the duties. Now coming to the rights. You all know, students, that rights and duties are two sides of the coin. Without one, the coin is not complete. It cannot become a legal tender in the market. So when there are duties, there are rights. The agent, while doing some job on behalf of the principal, enjoy some protections. The law give him certain protections. And what are these protections? We will discuss them. Retention of money. An agent has the right to retain all his claims out of the sums received on behalf of the principal. The claims may be regarding remuneration, advances, or reasonable expenses incurred by him in the business of agency. Let's say you have a franchise, Mr. X, and Y is his agent. Y is running the franchise on behalf of X. He will deduct all the expenses from the accounts of the franchise. That is what remuneration. If he pays some money on behalf of the principal, all these will be deducted from the income, and whatever is left, that will be given to the principal. Remuneration is his right. As we live in this world and we have many needs and wants, we fulfill those needs and wants through money, and money is again given in the form of remuneration to the agent. As somebody is working in a company as a manager, sales, he transact business in the best interest of the company, but he has a right to be remunerated as per the agreement between the employer and employee. Earn. An agent can retain the goods, documents, or property of the principal until the amount due to him for commission, services, or expenses is paid to him. The agent can secure his remuneration and other expenses which he incurred while doing business on behalf of the principal until and unless he pays all his dues. ओके, इसको आप इस तरह स्टूडेंट समझे कि आप जो हैं मिस्टर वाई जो है वो एजेंट है एक्स का. एक्स ने जो है बिजनेस किया है ऑन बिहाफ ऑफ एक्स. वाई ने बिजनेस किया है ऑन बिहाफ ऑफ एक्स हु इज principal. Now Y incurs some payments. He gives payments to the electricity bill and other things. He has a franchise. Now all these dues should be cleared by the principal, and until he clears the dues of agent, he will not return whatever he possesses, the property, title to property of principal. When he clears his claims against him, then the the principal has the right that he should be delivered back all the property and other things which the agent has on his behalf for transacting any business or doing any business, let's say full-fledged business. Indemnity for lawful acts. Let's say an agent acts in good faith, and some losses occurred in business transaction, so he is indemnified by law. In the principal must compensate him for those losses, and if he neglectfully acts on behalf of the principal, then the principal then the right of indemnity abrogates, and he will pay back the losses the principal due to his negligent behavior. Indemnity for acts in good faith, very much similar to the first. When he acts in good faith, he is indemnified, but if he does not acts in good faith and there are some bona fide intentions, then the agent is not indemnified by law of equity. Compensation for injury. Let's say the agent while performing duties on behalf of the principal incurs some injuries. Let's say he is a driver and driving a company car. Now an accident occurs in which he goes through some surgeries and injuries, and whatever the medical expenses are, it will be borne by the principal, by the company. And if let's say he is disabled, then the law allows him that he will be early retired and he will be given pension for rest of his life per set formula as the law directs. So these are the rights as agent and the principals. They work with mutual consent, and the relationship is that of trust. So you guys can fully understand that it should be clear, and there should be no harm from principal to the agent, and the agent must act in good faith on behalf of the principal while transacting some duties on his behalf. Now boys, coming to the next slides, that there are some duties of principals also, because agents are like slaves and they are working for or on behalf of the principal, their masters. So the master must act in a good and a justful way towards them. Remuneration, they must give on time remuneration to their agents, that is servants, whatever. Indemnity for lawful, if they act in good faith, lawfully, and does not go out of the law, whatever the agreement between the principal and agent is, and whatever authority the principal delegates to the agent, he works within that authority, then all his acts are lawful. And if there arises any financial obligation, it will be indemnified by the principal. Indemnity for acts in good faith. For example, he acted in good faith. The principal is, let's say, out of country, and he has some perishable goods in his godown. Now he feels that the goods will be perished if not sold to the market, and as he is unable, the agent is unable to contact with the principal, he can sell them to the market, and whatever the amount comes, collects from the buyer, that should be deposited in the principal account, and the principal will indemnify his acts. Compensation, as I have given you the example of driver. The driver incurred some injuries while he's kept driver by us, let's say Comsets. Comsets should compensate him. Now coming to the last slide, that is once the agency is created between the principal and agent, you guys know that there must be some end to it. When the business is transacted or the objective of the contract of agency is achieved, it should be terminated. Agreement, if both the agent and principal agrees and they terminate the agency, as Comsets, any organizations has a driver, and the organization wants him to leave, and he also give his consent that on certain terms and condition I will pre-retire before retirement age, then they can terminate the agency. Revocation by the principal can revocate the agency before the stipulated date, whatever is decided between the principal and agent, but he cannot go beyond certain limits, as the national laws have imposed on principal certain obligations. Revocation by the principal can revoke the authority of his agent at any time before the agent has exercised his authority. The principal can revoke the authority of his agent for future transaction. In order to revoke the authority, a reasonable notice must be given to the agent by the principal. B employs C as his agent for 1 year. B terminates the agency of C after 2 months by giving a reasonable notice. I hope it will be clear to you, students. Revocation by, now agent can also revoke and move out himself from the agency, but by reasonable notice and with a good reason. Completion of business, for whatever the agency was created, that objective has been achieved by the agent. Let's say A appoints B is his agent to sell his house. Now he sold his house. Now the business is completed, and automatically the agency terminates. Expiry of time, A appoints B as manager of his company for 2 years. 2 years pass, the contract has expired. On expiry of the contract, 2 years, the B as agent of A moves out of the job. Death of principal or agent, any of the two, when any of the two dies, then one party go out due to natural death, automatically the agency come to an end. Insanity of principal or insanity of even agent, if any of them become of not sound mind, they cannot decide reasonably in a sensible way, so then due to mental incapacity of any party, the agency can be terminated. Insolvency of principal, the principal become insolvent, he is unable to pay dues of the business. So insolvency comes to an end, destruction of the subject matter. Let's say Mr. X, who is principal, appoints Mr. Y to take care of his horse. Now the horse dies. When the horse dies, the agency comes to an end. Alien enemy. Let's say Pakistan and Afghanistan has a good relation, but at any time a war broke out between the two countries. Then once friendly countries become enemy, so any agreement, any agency of the two nationals come to an end due to the changing circumstances, change of law. The law itself forces certain business to be unlawful. Let's say A appoints B to sell certain toys on his behalf, manufacture certain toys on principal behalf. Now the government bans selling of such toys to the children due to any health or safety reason. So once a legal business has become but illegal, the agency automatically come to an halt, to an end. These are the different aspects of contract of agency, very important aspect of our daily business transaction and business organizations. We know that the original owners, the real owners of any business, especially the multinational companies, are shareholders, but all the business is transacted by the professional management, i.e. the CEO and his team, the marketing, finance, HR and production directors. But they does not own the company, but they are fully authorized and powerful to do all the business transaction of the company, and but they are still agents, as they cannot sell the company to anyone, and they act on behalf of whom? On behalf of the shareholders, who are the real owners, and they will act in good faith. There is a relationship of trust between the shareholders and the managers. The managers must maximize the profit of the shareholders. And now the new theory in business is that it is a multilateral contract. There are multilateral agencies created in business. They should not only act in good faith towards the shareholders, but also to the other stakeholders. I pay government proper taxes, give employees proper health, environment and safety conditions, and give them proper remuneration, trainings, and also do some social activities like charity and education and medical facilities that are again job of the companies. Hope you have you have understand all these topics, and it is a bit technical as the law aspects, or a bit has some technicalities, but when you go through these, listen to this lecture and go to your books, as you all have, then you will be able to fully grasp the concepts of the contract of agency and how agency is created, different kinds of agents, right, duties of both agents in principle, and at the end how agency is terminated. Your questions will be more than appreciated, and will really develop a good discussion in the live session. Stay safe and blessed, and your question will be welcome. Khuda Hafiz, students.